The next case of State of Kansas versus Riggins, 126841. And counsel, when you're ready, you may approach.
Good morning. May it please the court. Tyler Winslow, Assistant Solicitor General on behalf of the petitioner appellee, the state of Kansas. I'd again request 3 minutes for rebuttal, Your Honor.
Thank you. 3 minutes is granted.
Before I get too far into the argument, I'd like to address the record question the court issued an order for about volume 26 of the record. The state's belief is that it is in fact part of the record. Once we received the court's order, I started digging in. It's a physical volume. It's the trial exhibits that were on a flash drive. I dug in a little bit farther. I filed the appellee's brief on February 5th of last year. We still had in our possession at that point the flash drive. I think that is the same day that the appellate court the clerk's office here requested the record. Butler County Clerk's office didn't actually have possession, and there had been discussion between the parties and with the clerk's office while the parties were briefing about getting volumes 25 and 26 added to the table of contents. That appears just to not have happened. I called the clerk's office, both I and the appellate defender's office's administrative personnel were trying to talk through with the clerk.
The Butler County Clerk?
Yes, Your Honor.
Okay.
Yes, Your Honor. So the district court had the exhibit. They had the flash drive. We kind of spot checked what I was citing as volumes 26 as including, for example, state's exhibit. I think it was 78 and 86, things like that, just to make sure that we were talking about the same thing, and she was able to explain that. So I think it's just it didn't make it onto the table of contents that this court has, but it is part of the record on appeal.
Well, I think I can represent that it's not present in the record, at least my review of the record.
I understand. It's because it's a not physical volume. So I think it just didn't make it up to this court.
Well, where is it?
It's in Butler County, Your Honor. Your Honors. Both parties had it. And in the alternative, if necessary, it would be volume 26. I reread Rule 3.02 again yesterday about the record on appeal. I think at this point, if it's not in the record, it can still be made part of the record.
If I'm understanding you right, you're just saying it was made part of the designated record, but there was a hiccup somewhere along the way because it was never transmitted to the appellate courts.
Yes, Your Honor.
Okay.
And both parties did have it when we were briefing the case. There's both parties actually had to request fourth extensions from the Court of Appeals to make sure we actually got the flash drive from the Butler County Clerk's office. Any further questions about the record?
Okay, so I just want to make clear. So right now it's in Butler County.
Yes, Your Honor.
And is it in the process of?
Yes, Your Honor. She was actually,
Okay.
the clerk was actually preparing a table of contents yesterday after I called her. I asked her if it was already in the record on appeal. And to be honest, I'm not sure what the answer. She just started referencing the exhibits.
I'm less concerned about the table of contents than the
record itself, Your Honor. That makes sense, Your Honor. And it is with the Butler County Clerk's office. Ultimately, the case in the state's mind, this case boils down to too little too late for a motion for self-defense immunity under KSA 22 or 215231 as established by 22-32-084. In general, factually, a household dispute wound up with one of 4 people in the house, Dana Haynes, being murdered by Riggins. And then at trial, he was convicted of voluntary manslaughter based on a theory of sudden quarrel. I'll address primarily the self-defense immunity procedure, first addressing the timeliness and then the reliance on the preliminary hearing transcript. Time dependent, I'll try to get to the self-representation issue post-trial. And then I will rely on the briefing for the remaining issues preserved by the conditional cross petition. With respect to the timeliness of a self-defense immunity motion, the first statute I'll reference is KSA 21-5231, the self-defense immunity motion statute, essentially. A relatively short read, what it does is establish that a defendant who uses self-defense is entitled to immunity from prosecution. That's laid out by A. And subsection C says a prosecutor may commence a criminal prosecution upon determination of probable cause. So what that statute tells us is that prosecutors can charge even if there's a potential question of self-defense, notwithstanding the language of 5231. What KSA 22-32-084 does is establish a timeline for when that motion needs to be filed. Specifically, there's a 21-day time limit upon arraignment that can be extended when the reason is not known and not discoverable by the defense with reasonable diligence.
Can I ask you about that statute?
Yes, sir.
I'm trying to read all of the various subsections 1 through 7.
Yes, Your Honor.
Kind of together in harmony, in particular 3 and 4. And one way that it seems like we could read 3 and 4 is that subsection 3 controls the timing of the assertion of a defense at trial, meaning that, yeah, there's a greater time period that let's take self-defense, for example. To assert that as a trial defense under subsection 3, it needs to be asserted by the defendant before trial. But if you're using that same immunity under self-defense as a vehicle to dismiss the complaint, that pushes you into subsection 4 and those specific timing requirements. Is that how you're reading those two together?
If I'm understanding you, the self-defense immunity pretrial would be under subsection 4. And if you're asserting a self-defense immunity, a self-defense claim, essentially as an affirmative defense, just as you would any other defense, that would fall into the category 3.
Yes.
Yes, Your Honor.
The timing and the exceptions appear different between 3 and 4.
Yes, Your
I'm
Honor.
just trying to confirm.
Yes, Your Honor. With subsection 3 addressing good cause as if you don't use it, you lose. I refer to it as a use it or lose it provision for certain defenses. For the one that came to my mind was statute of limitations. If you don't raise the statute of limitations before you're found guilty, that's too late. And I'd also point the court back to the language of subsection 3. Defenses and objections based on defects in the institution of the prosecution or in the complaint, information, or indictment. So reading 22-3208-3 in harmony with 5231C, where a prosecutor may commence a criminal prosecution upon a determination of probable cause, that's how the 5231 motion does not fall into 32083's the district court can find good cause. And in actuality falls within subsection 4, where there has to be a more specific reason that it wasn't known to the defendant that he could raise the self-defense immunity issue, and that failure to know that was could not have been overcome with reasonable diligence.
Counsel, can I ask a question?
Yes, Your Honor.
What authority can you point us to that would indicate that the invocation of statutory immunity is a motion to dismiss for purposes of this statute 3208?
Well, the first one is actually the one we supplementarily briefed between the parties, State v. Jones. The one of the paragraphs, and it's at 298 can 334, 32084 applies. It is unquestionable, I think, is the language that court used, that 32084 applies to a self-defense immunity motion here. I'll explain why I didn't cite that to the Court of Appeals, is because I didn't think it was controlling given the actual factual scenario presented by Jones. But I do think that that's some authority this court can rely on. I'd also point the court back to Hardy's language that Hardy 305 can at 10 to 1012 is where they really discuss the self-defense immunity procedure. And it seems clear that it's got to be early in the process, as early as possible in the process, so that the district court can actually perform a gatekeeping function, and that we're not on the eve of trial litigating what is essentially going to be the same issue, that the primary issue that came up at trial, which is this a valid self-defense claim? And so that's why the state's position here is that the motion does need to be filed within 21 days or with a showing of reasonable diligence. The pleas were entered in this case on January 6, 21. The motion to dismiss was initially contemplated at a pretrial hearing captured in Volume 5 on March 31st and filed on May 28th. Either way, it would have been untimely under the statute. And ultimately, the ruling, which the Court of Appeals said wasn't sufficient, is that the defendant had ample time to take this. He stumbles over the word motion, but to take this motion up prior to the eve of trial. That's at Volume 6, 84. Even if that's not the case, the district court here relied expressly on the preliminary hearing transcript, and there was no objection. And so there's a little bit of distinction here in the argument the Court of Appeals accepted, and I see I'm about to run out of time, is that it should have, the district court should not have relied on the preliminary hearing transcript. Seeing that I'm out of time, I'll stand on the briefs pending further questions of the court.
I do have a question under subsection 4
Yes.
of 223208. You have the first, that says the 21 days. And then it says that the period for filing such motion may be enlarged by the court when it shall find that the grounds were not known. Have you basically, did the state basically waive this argument by not challenging the fact that the judge actually heard it on the merits?
I don't think so, Your Honor. I think the district court conducted the hearing, and it seems clear that it's a matter of judicial economy to let him present the case so that this court ultimately would have a record to address his substantive self-defense immunity claim under the self-defense immunity statute. But the state continuously, at argument on that motion, still said it's untimely. I don't think that.
Okay, so I guess I didn't realize. Okay, so when it happened, when the motion for immunity was filed, the state came back and said, this is untimely.
Yes, Your Honor. That was one of the arguments at the district court. And it was, I believe, in writing and in verbally made at the.
But the court decided to hear it anyway.
The court took the defendant's evidence. Yes, Your Honor.
So can we, infer from that the court found that there were grounds?
But for the district court's ruling, which is captured at Volume 6, 82 to 84, where he says the defendant has had ample time to bring this up prior to the eve of trial. That ruling appears to be specifically pointing to that that standard in the state's reading of it under 32084, that the court can enlarge the time, sure. but it should be related to a defense not known to the defendant, and that could not have been discovered with reasonable diligence. That certainly wasn't the case here. And as argued to the Court of Appeals, even if that's not sufficient, then it could still be this court could still affirm the district court is right for the wrong reason if that's not actually what happened.
So you're saying that even if we were to infer that the district court, by reaching the merits, made the findings to enlarge the time, there's nothing in the record that would support that implicit finding?
Yeah, sure.
Any further questions, colleagues? Thank you very much for your.
Thank you.
May it please the court. Again, I'm James Ladd of the Appellate Defender's Office representing Wayne Riggins. I guess I'll start with the timeliness of the motion.
Can I just preliminarily, do you agree with the state on the record question? Do you agree volume 26 is in the record, but just in Butler County?
I do agree with that, Your Honor. I filed a motion to add it to the record. We had many communications. I looked yesterday with the clerk trying to get it to the record. When my administrative staff got the exhibit and they labeled it volume 26, I assumed since I filed the motion to add it to the record and we got it, it was. And so I think it is part of the record, like a hiccup. So I think Your Honors can still go get that now and still look at it, and it's a valid part of the record. As to timeliness of the motion, so I hopefully Your Honors will agree, I can see a clear analytical path for this court to say Riggins wins. In Jones,
I didn't hear what you said at the very end.
to say that
clear
Riggins wins, to
What?
say that my client wins.
Oh, got it. Okay.
Sorry. To start with the timeliness. In Jones, the 2013 case, this court said that a filing of a immunity motion before trial or a dispositive plea is timely. The state has not argued to overturn that. This court reiterated that finding in Barlow, I think it's Barlow, in a 2016 case. And so we would say that's our first path to victory on timeliness.
Well, doesn't Jones specifically say that 3208 applies to a stand your ground motion?
It does say that. It does, but it also says that a filing before trial is a timely trigger of the immunity statute.
So is Jones just does it have an internal contradiction?
I would say no. So first I say no. I say why can't what was that issue in that case was whether or not the defense could raise that for the first time on appeal. And they said, no, you can't. And so I see what you're getting at, that you're talking about the 21-day time limit and the raise before trial. So to the extent it does, so I still want this court to stand by that case because the state hasn't argued to overturn it. Second, to the extent it does have a contradiction, it's wrong that it even says it applies. If you also read.
So are you asking us to reverse the holding in Jones?
Oh, I'm asking this court not to revisit it. And then as I stated in my supplemental brief, if this court is going to revisit Jones, it should actually extend it. And here's why. First, when you look at Jones, it actually called this was a 2013 case, and there's been some really messy case law, respectfully, about the immunity statute. The court in Jones actually called the immunity statute an affirmative defense when it said that 3208 applied. Well, throughout the years, we know that is not an affirmative defense. It is a true immunity statute. And then based on the plain language of the immunity statute, and including this court's language in Barlow, which I argued in my supplemental brief, when we're talking about prosecution, that goes all the way to the pronouncement of sentence. So this court should actually find, looking at just the specific statute, that it has its own timeliness within it. And that is the defense could raise it any time until sentencing. So 3208 doesn't even apply based on the plain language of the statute and based on the more specific statute controlling. And that's basically what this court said in Barlow. They just said it as to a district court, but the exact same reasoning would apply here. So just to reiterate, I want this court to stand with Jones and Jones' statement that filing before trial is timely, but if it revisits Jones, it should extend it.
Jones said that, and I think the issue of it being an actual immunity, not an affirmative defense, was settled prior to Jones. That's the Ultraris decision. And Jones said, because it's an immunity, it needs to be asserted as early as possible prior to the trial. And then the court went on to say 3208 applies. And isn't that consistent across the board? I mean, all of that is before the trial. But the impact of Jones is you got to do this right away. And part of that is inherent in the fact that it is an immunity.
Right.
It defeats the purpose of immunity to bring this up, late, because
Sure.
you've already gone into a lot of the burdens that it was intended to avoid.
Right. So my first response to about bringing it up as early as possible. My reading of the immunity statute is this is the defendant's right to immunity. If they file a motion, yes, we want the court to decide it as soon as possible. But even if they wait till later, they still have that right to immunity. I mean, the way I think of it is if you find after an immunity hearing that they are immune, it's like kind of like everything that happened before shouldn't even have happened. So it only hurts. I mean, it would only hurt the defendant to raise it later. I don't know why that would be held against them. When I read this court's case law talking about it should be decided as early as possible, that's just for the benefit of the defendant. So we aren't filing a motion and then going through all these other things. That needs to be decided. But if the defendant wants to sit on it, or it's like in the Court of Appeals opinion when they talk about there may be reasons for them to wait. Maybe the defense wants to see what the evidence is. Once they want to go through the preliminary hearing, then they want to decide what their defense is going to be. And then they decide, well, let's do this immunity. So talking about how early you raise it, to me, that's just the right of the defendant whenever they want to do it.
But is there anything in the immunity statute that informs the court about waiver of that immunity? I guess if it's a waivable immunity, can't it be subject to rules of criminal procedure about waiver?
Sure. My answer is no, based on saying that the criminal prosecute, they're immune from the entire prosecution.
The scope of the immunity.
Right. And this court said that in Barlow. This court said prosecution goes all the way to sentencing. If a defendant files a motion for immunity after a jury trial and after conviction, and then the court decides that immunity applies, they have still been immune from at least some of the prosecution because there wasn't pronouncement of sentence. So that part of the statute is what I'm relying on to say that it can be raised all the way until pronouncement of sentence. And that's what this court said. I just want to reiterate, this court said that exact same thing in Barlow. That's how that could be interpreted. Moving on, I suppose, to the merits of the claim. I think an easier way after reviewing everything to look at this case is really, this is just a sufficiency of the evidence issue. And I would really point to some of this court's recent cases regarding restitution, where they talk about substantial competent evidence is really equates to sufficiency of the evidence. By filing the immunity motion, the defense has put in the state's burden of production, burden of persuasion, burden of proof, has made that part of the whole thing. So what we're really arguing is we don't even have to get into preservation. We don't have to get into this preliminary hearing stuff because it simply wasn't admitted at the immunity hearing. This is just sufficiency of the evidence. There's no reason to object because there's no evidence to object.
Why isn't there a reason to object if the district court is going to rely on testimony that was heard at the preliminary hearing? There was no objection to that procedure. Am I right?
No, you are correct. There was no defense objection.
And then the Court of Appeals reversed, saying it was improper to consider that testimony absent some sort of notice. But why wasn't that objection raised? What's supposed to happen when the district court is proceeding in that fashion, utilizing the testimony from preliminary hearing?
Sure.
Counsel doesn't raise any objection. Why? And now later there's a reversal based on considering that evidence when there was.
Right. I understand what you're saying.
Yeah. Well,
so
what's the state supposed to do in that scenario if they're proceeding in a fashion and the district court is proceeding in a fashion that you now complain of?
Well, to start with the state, they should have either called those witnesses, or if they were unavailable, then they should have admitted the preliminary hearing testimony under the rules of evidence for an unavailable witness to get around the hearsay rule. As to the district court, I mean, my only answer, respectfully, is that's what the law has said. Is that I think since at least Hardy, for nearly a decade now, since Hardy, this court has said that you either have stipulated facts or you have a hearing based on evidence pursuant to the rules of evidence. And that preliminary hearing testimony was never admitted. So of course, the defense could have objected in close when the state talked about it in closing argument, or when the district court started ruling on it. But I don't think there's any rule that says that once a district court makes an incorrect legal ruling, that we then have to object again. That court ruled, and
It was never, I mean, you say again, it was never objected to.
correct. So they don't have to object again or ever, because it's just we're just arguing a legal ruling, sufficiency of the evidence. I'm not arguing the preliminary hearing testimony was wrongly admitted. It just wasn't admitted at all. So it shouldn't have been considered. And I would equate this to the restitution cases where this court considers stuff without objection as well. Because it's the sufficiency evidence and we're putting the state to their burden. So unless there's any other questions, I would stand on all my briefing, and I would note to the court that this court did grant our motion to expedite, and Mr. Riggins and myself would respectfully and humbly ask that this court issue an expedited opinion. Thank you. Yes, Your Honor.
I just want to look at one thing. Oh, I guess it's still outside 21 days. I was going to say, the pro se motion, could it possibly be construed liberally as a motion for immunity hearing? Because he asks for, I mean, he says self-defense.
It could. It was filed, it was filed before arraignment. Because it was, if I remember correctly, it was filed in 2020.
Well, oh, this looks like March 28th, Oh, electronically filed April 1st, 2021. So it's still outside, I guess.
Okay, my mistake on the record.
Yeah. Okay, thanks.
Thank you, Your Honor.
Any other questions, colleagues? Thank you, Mr. Latta. You reserve 3 minutes.
Yes, Your Honor. I do think, if I recall correctly, I looked at the pro se motion again yesterday. I believe it was March 20th of 2020. That was probably placed in the mailbox and
Right.
didn't actually make
Yeah,
it.
that's what he wrote on there, March 28th.
Which would be before the preliminary hearing. So the state's position there is that it would have, the motion didn't necessarily have to be considered in the first place because Riggins had counsel at that point. He had the same defense attorney that represented him at the preliminary hearing, and he could have raised the self-defense immunity claim at the preliminary hearing, and this whole issue would never have even arisen. Secondarily, at the immunity hearing in Volume 6, not only did Riggins not object to the state or to the district court's clear reliance on the preliminary hearing testimony, he went first without objection. He did not say, Your Honor, it is the state's burden. This is my motion, but it's a shifting burden, and the state should have to present evidence.
Do you agree with the defendant's characterization that the preliminary hearing evidence was not, quote unquote, admitted in the?
Yes, Your Honor. I'd agree with, there was no formal admission of the preliminary hearing transcript. However, the district court expressly relied on the preliminary
The
hearing.
reason that might change things is our ability to invoke when I say our, I mean appellate court's ability to invoke a prudential exception to a failure to preserve is different under the contemporaneous objection rule as it is under just the general failure to raise the issue below.
Yes, Your Honor.
So we need to know, are we under the contemporaneous objection rule or are we under the general preservation rules?
I think for that particular issue, that would be under the preservation rules.
The general rules.
Yes, sure.
So and then there are,
And
do we have to review the court? I think we've said when the Court of Appeals invokes a prudential exception to preservation, we review that decision for an abuse of discretion.
I'm not sure on the case law, but I believe it, Your Honor.
How did the Court of Appeals abuse its discretion by prudentially deciding it could consider this question?
As I think I argued this in the petition for review, the benefit falls. Essentially, the preservation exceptions allow the appellate court's discretion out of a fundamental fairness perspective. And it's fundamentally unfair because of the manner in which this was raised and the fact that the district court actually relied on it and there was no objection below. There was no opportunity for the state or the district court to correct any error.
Well, isn't it just a pure question of law, though?
The preservation exception, Your Honor?
Right. Let me see if I can get this straight. The Court of Appeals chose to consider whether or not the district court made an error of law by improperly relying on preliminary hearing testimony.
Yes,
Do
Your
you
Honor.
agree with the way I stated that?
Yes, Your Honor.
And isn't that one of the prudential exceptions to,
Yes, Your Honor.
to preservation?
Yes, Your Honor. But it is
Why was the Court of Appeals wrong?
because of the fundamental unfair result that follows because it is the failure to object below that prevented anyone from remedying the issue, both before any evidence was presented. There was the state was not asked to present any evidence in the first instance. Riggins was. It's volume 6, page 4, I believe, is where the actual evidence started. And so it is the fundamental.
You're saying it's unfair to the state because had this been raised, you would have just introduced the evidence.
Or at least figured out a way to proceed from that point, given the timing of the motion.
That makes sense. Thank you.
And so I'm out of time. I'll stand on my written briefs and ask this court to affirm the district court and reverse the court of appeals.
Any other questions, colleagues? Thank you very much for your arguments this morning. That concludes the 9 a.m. docket, and court will be in recess for 20 minutes until 10:50.